Hi, this is Naganeethu. Here I'm going to present on the topic Doctrine of Lis Pendens under Property Law. Objectives of presentation is to understand meaning and principle, basis of lis pendens, applicability, ingredients, essential conditions for application of Section 52, effect of the doctrine, lis pendens and doctrine of notice, few illustrations and some case laws. Introduction. The law incorporated in Section 52 of the Transfer of Property Act 1882 is based on the doctrine of lis pendens. The provision in Section 52 states as during the pendency of suit or proceedings, property cannot be transferred or otherwise dealt with, and if so transferred, the transferee is bound by the decision of the court whether or not he had notice of suit or proceeding. Meaning of the term lis pendens. Lis means litigation, pendent means pending. So, lis pendens would mean pending litigation. The doctrine of lis pendens is expressed in the well-known maxim ad lite pendente nihil innovator, which means during pendency of litigation, nothing new should be introduced. The principle in this doctrine is that during pendency of any suit regarding title of a property, any new interest in respect of that property should not be created. Therefore, in essence, the doctrine of lis pendens prohibits the transfer of property pending litigation. This doctrine is an old and has been operating in the English common law. Under this doctrine, the judgments in the immovable properties were regarded as overriding any alienation made by the parties during pendency of litigation. Let us see the basis of lis pendens, which is necessary rather than actual or constructive notice. It may be said that this doctrine is based on the notice because a pending suit is regarded as constructive notice of the fact of disputed title of the property under litigation. Therefore, any person dealing with that property pending litigation must be bound by the decision of the court. For administration of justice, it is necessary that while any suit is pending in a court of law regarding title of the property, the litigant should not be allowed to take decision and transfer the disputed property. Lis pendens is therefore based on necessity, and as a matter of public policy, it prevents the parties from disposing of disputed property in such a manner as to interfere with court's proceedings. In the case law Bellamy vs. Sabine Turner, LJ, it was stated like, it is as I think doctrine common to the courts both of law and equity, and rests as I apprehend on the foundation that it would plainly be impossible that an action or suit could be brought to a successful termination if alienations pendente lite were permitted to prevail. The plaintiff would be liable in every case to be defeated by the defendants alienating before the judgment of decree, and would be driven to commence his proceedings de novo, subject again to be defeated by the same course of proceedings. Applicability of this doctrine is under Section 52 of the Transfer of Property Act, which expresses the principle pending litigation, nothing new should be introduced. It provides that pendente lite, neither party to the litigation in which any right to immovable property is in question can alienate or otherwise deal with such property so as to affect his appointment. Let us see one example. A land in dispute was recorded in the name of petitioner's husband, and after his death, his brother G, knowing it well that his brother's wife was alive and being sole legal heir without impeding her, filed a suit seeking declaration of khatedari rights, and thereafter she has been litigating being sole legal heir of the recorded khatedar. Despite the pendency of the suit and suit property is being prohibited from the being alienation or transfer during pendency of the suit, yet the respondent brother went on transferring the land, and therefore subsequent purchasers went on transferring the land. Such transfer would be hit by this doctrine of lis pendens. Section 52 would apply in case where the sales are made by a way of private negotiations and during the pendency of suit. Ingredients of this doctrine are: there is a pendency of suit of proceeding. The suit or proceeding must be pending in a court of competent. A right to immovable property is directly and specifically invoked in the suit. The suit or proceeding must not be coercive. The property in dispute must be transferred or otherwise dealt with by any party to suit. The transfer must affect the rights of other party to litigation. Essential conditions for the application of this section 52 are: firstly, pendency of suit or proceeding. This section applies only where a property is transferred during pendency of litigation. Pendency of suit is that period during which the case remains before a court of law for its final disposal. If a case is instituted in court, the first step is presentation of the plaint, and the last step is passing of the decree. So, the pendency of suit begins from the date on which the plaint is presented and terminates on the date when final decree is passed. Secondly, pendency in court of competent jurisdiction. The suit or proceeding during which property is transferred must be pending before a court of competent jurisdiction. Where the suit is pending before a court which has no proper jurisdiction to entertain it, the lis pendens cannot apply. Thirdly, rights to immovable property must be involved. Another condition for applicability of this section is that in the pending suit, right to immovable property must directly and specifically be in question. The litigation should be regarding title or interest in the immovable property. Where the question involved in the suit or proceeding does not relate directly to any interest in an immovable property, the doctrine of lis pendens has no application. Rights in movables. The doctrine of lis pendens does not apply where the suit involves right in movable properties. Standing timber is a movable property. Therefore, the section cannot apply where the issue before the court is right in respect of the standing timber. Fourthly, suit must not be coercive. Lis pendens is inapplicable if the suit is coercive in nature. A suit is coercive if it is instituted with a malified intention. Malified intention behind instituting a suit is inferred from the fact that parties to the suit know their respective rights in the property and there is no actual dispute. Such suit is therefore fictitious, and very purpose of the filing of the suit is to get judicial decision for some evil designs. Example, defrauding a third party. Fifthly, property is transferred or otherwise dealt with. During pendency of a suit, the property must be transferred or otherwise dealt with by any other parties to the suit. Thus, during pendency of suit, if the disputed property is sold or given exchange, is leased or is being mortgaged either by plaintiff or by defendant, doctrine of lis pendens shall apply on it and transfer would be subject to decision of the court. Lastly, transfer affects rights of any other party. The condition for applicability of section 52 is that the transfer during pendency must affect the rights of any other party to suit. Principle of lis pendens is intended to safeguard the parties to litigation against transfers by their opponents. So the words any other party here does not mean stranger to the suit. It means any other party between whom and the party who transfers there is an issue for decision which might be prejudiced by alienation. When the above mentioned conditions are fulfilled, the transferee is bound by the decision of the court. If the decision of the court is in favor of the transferor, the transferee's rights in the property transferred to him. If the decision goes against the transferor, transferee cannot get any interest in the property. Effect of this doctrine. A transfer or dealing by a party to a suit during the pendency of the suit or proceeding is not ipso facto void. It only cannot affect the rights of any other party to the suit under any decree or order that may be made in the suit or proceedings. Section 52 creates only a right to be enforced to avoid a transfer made pendente lite because such transfers are not void but voidable, and that too at the option of affected party to the proceeding, pending which the transfer is effected. Thus, the effect of the rule of lis pendens is not to invalidate or avoid the transfer but to make it subject to the result of litigation. Let us see what lis pendens and doctrine of notice is. The rule contained in Section 52 of the Transfer of Property Act is, however, not based on the doctrine of notice but an expediency. The lis pendent rule does not annul the transfer but renders it subservient to the rights of the parties to the litigation. According to this rule, therefore, whosoever purchases a property during the pendency of a suit is bound by the judgment that may be made against the person from whom the derived title, even though such a purchaser was not a party to the action or had no notice in the pendent litigation. Let us see some illustrations. In the first case, A, B, and C are brothers. C is residing in a distinct town while A and B are residing together. A files a suit for partition and does not implicate C or his father X. Though X and C are not parties to the suit, yet the subject matter of the suit is the same. Neither X nor C can legally and validly transfer or alienate his share to the third party. In such cases, the ultimate decree is likely to affect the shares of X and C. Thus, there may be cases where a party may not be locked in a civil suit or proceedings, yet such a party may be affected by the judgment or decree in such a suit. In the second case, A sues B in respect of the house in B's possession. During the pendency of the suit, B sells the house to C. A's suit is dismissed. The transfer of C holds good. Thus, here the purchaser is bound by the result of the litigation. In the third case, A sues B in respect of the house in B's possession. During the pendency of the suit, B sells it to C. A's suit is decreased. The transfer to C is voidable and A's right to take the house is not affected. Let us see some case laws. In the first case, Srimati Sayar Bai versus Srimati Yashoda Bai. When a party to the suit tries to alienate a larger interest in the immovable property than the possession, the transfer would be hit by this doctrine, and such a transferee would still be a representative in interest of the judgment debtor in execution of the decree passed against the predecessor in interest of the transferor. In the second case, Amarnath versus Deputy Director of Consolidation, it was held that party is said to be a party to the suit if the judgment is likely to affect the proposition of such a party and the decision would be obligatory on him. Thus, when A, B and C are brothers, C is residing in the city while A and B are residing jointly. A files a suit for partition and does not implicate either C or his father X. Though C and X are not any parties to the suit, yet the subject matter of the suit is the same and neither X nor C can legally validly alienate his share to the third party. In such a case, the ultimate decree is very much likely to affect the shares of X and C. Thus, there may be a case wherein a party may not be locked in a civil suit or proceedings as a valid party to the suit, yet such a party may be affected by the judgment or decree in such a litigation. I conclude by saying that the doctrine of Lis Pendens and its principles are enshrined under the Section 52 of Transfer of Property Act 1882, are in compliance with justice, equity and good conscience as they rest upon a foundation which is equitable and just. That is, alienations of properties have pending litigation or suit cannot be allowed to prevail, as it will be impossible to bring that suit to a successful termination. It also postulates a condition that the alienation will in no matter affect the rights of other party under any decree which may be passed in the suit unless the property was alienated with the permission of the court. It has this doctrine has the doctrine of necessity as its basis rather than doctrine of notice. For the administration of justice, it is far vital that at the same time as any suit is pending in the court of law concerning title of the property, the litigant must not be allowed to take decision themselves and alienate or transfer the disputed property. Hence, Section 52 of the Transfer of Property Act 1882 plays a vital role to ensure the justice is well served to the deserved and that no person's right is crippled by another to his own satisfaction and will. Thank you.